Form FL-810 is the California Judicial Council booklet you're required to read and understand before filing FL-800. Here is what it covers, the eligibility checklist inside it, and why you sign a statement confirming you read it. What is Form FL-810? Form FL-810 is a booklet titled Summary Dissolution Information, published by the Judicial Council of California under Family Code Sections 2400 through 2406. It runs about 20 pages and is available in English and Spanish from any county superior court clerk's office or directly from the California court's website. The booklet exists to make sure both people understand exactly what they are agreeing to before they use the summary dissolution shortcut. It covers who can use the procedure, what steps you'll have to take to start and finish the case, when it would help to see a lawyer, and what risks you take by using this procedure instead of the regular dissolution process. Why you're required to read FL-810 before filing FL-800. Summary dissolution trades procedural simplicity for finality. There is no court hearing, and once your case is final, you generally cannot ask for a new trial or appeal the outcome the way you could in a regular dissolution. Because that trade-off is significant, California requires both people to confirm, in writing and under penalty of perjury, that they read and understood FL-810 before they can use Form FL-800. If you're still confirming eligibility or want the step-by-step walkthrough of the joint petition itself, see our guide on Form FL-800, California Summary Dissolution Guide. This article focuses specifically on what the FL-810 booklet contains and why it matters. Key terms: community property, separate property, and community obligations. FL-810 opens by defining three terms that determine whether you meet the requirements for summary dissolution and how your property gets divided. Community property. Community property is everything you and your spouse or domestic partner own together. In most cases, that includes money either of you earned while living together as spouses or domestic partners, and anything either of you bought with that money, regardless of whose name is on it. Separate property. Separate property is everything you each own separately from each other. That generally includes anything either of you owned before marriage or registration, anything either of you earned or received after separation, and anything either of you received as a gift or inheritance at any time. Community obligations. Community obligations are the debts you owe together, generally meaning any debt either of you took on while living together as spouses or domestic partners, even if only one name is on the account. Figuring out your exact separation date matters here. It is the dividing line the booklet uses to sort what counts as community property versus separate property, and what counts as a community obligation versus a debt that belongs to only one of you. The 16-point eligibility checklist inside FL-810. FL-810 lays out a checklist of statements that must all be true at the time you file FL-800. If even one is not true, summary dissolution is not available to you. The statements cover, among other things, both of you have read and understand the FL-810 booklet. You were married or registered as domestic partners 5 years or less, measured from the date of marriage or registration to the date of separation. No children were born to the two of you together before or during the marriage or domestic partnership, and you have no adopted children under 18. Neither of you is pregnant. Neither of you owns any part of any land or buildings. Property and debt dollar limits. 3 of the eligibility statements involve specific dollar figures. As of the booklet's April 2025 revision, FL-810 sets these limits. Community property not worth more than $57,000, separate property for each spouse or partner not worth more than $57,000, and community obligations of $7,000 or less. Cars and car loans are excluded from all 3 totals, but you still have to decide who keeps each vehicle and who pays any remaining loan in your property settlement agreement. These dollar thresholds are set by statute and are updated periodically. Do not rely on a number you saw somewhere else or remember from a prior year. Confirm the current figures in the official FL-810 booklet or with your county superior court self-help center before assuming you meet the requirements. What you give up with a summary dissolution. FL-810 is direct about the trade-off involved. With a regular dissolution, Either spouse or domestic partner can ask for a court hearing or trial, and if either side is unhappy with the outcome, it is generally possible to ask for a new trial or appeal the decision to a higher court. With a summary dissolution, there is no trial or hearing, and you generally give up the right to a new trial or an appeal. Financial disclosures and the property settlement agreement. Even though summary dissolution skips a court hearing, California law still requires both people to fully share information about their property, debts, and income before signing the property settlement agreement. FL-810 says this generally means each spouse or domestic partner completes and exchanges an income and expense declaration, Form FL-150, all tax returns filed in the last 2 years. The property worksheets built into the FL-810 booklet, or alternatively Declaration of Disclosure Form, FL-140 together with either Schedule of Assets and Debts Form, FL-142, or Property Declaration Form, FL-160. The filing steps and how revocation works. FL-810 walks through the process in numbered steps. In broad terms, after completing your disclosures and property settlement agreement, you fill out and sign Form FL-800, and you also fill out Form FL-825, Judgment of Dissolution and Notice of Entry of Judgment, at the same time. Both are filed together with the Superior Court clerk along with 2 self-addressed, stamped envelopes, and the filing fee, or a fee waiver request if you meet the requirements. For help with the fee waiver process, see our Form FW001 guide. The court holds your case for the mandatory 6-month waiting period before your dissolution becomes effective. When you might still want a lawyer. FL-810 recommends seeing a lawyer in several specific situations, even though summary dissolution does not strictly require one. You are unsure about your exact separation date or how to value or divide your property. You live together before marriage or registration and may have additional rights connected to that period. You are an undocumented person who became a lawful permanent resident based on your marriage to a U.S. citizen or lawful permanent resident. FL-810 carries a special warning that obtaining a dissolution within 2 years of your marriage may put your immigration status at risk, and recommends consulting a lawyer before filing. Common mistakes to avoid. Signing the statement on FL-800, confirming you read FL-810, without actually reading through the eligibility checklist carefully. Assuming last year's dollar limits still apply instead of confirming the current figures before filing. Filing FL-800 without completing the required disclosure exchange first, which can later give the other spouse or partner grounds to set the judgment aside. Losing track of the blank Notice of Revocation, Form FL-830, that you receive with your paperwork. Not reading the special warning about immigration status if either spouse became a lawful permanent resident through the marriage. If keeping track of all of this by hand feels like a lot, that is exactly what Virdix is built for. The wizard at Virdix.co walks you through the summary dissolution eligibility questions in plain language and prepares your FL-800 and the other forms you will need. Virdix is a document preparation service, not a law firm, so this is not legal advice, but it can help make sure your paperwork is complete and consistent from the start.